So far, I have outlined my proposed system for making local, quick, final decisions on immigration claims following an interview in a pub conducted by ordinary British people on a pub immigration jury. We have seen the colossal legal obstacles to this proposal. This has led us to start exploring the option of simply ignoring the legal consequences and relying on a democratic mandate from the people. And hopefully the people will have elected a majority of members of parliament to back this proposal. But let's dial it back a stage to consider what a new parliament might do, at least to try to put pub immigration juries on a legal footing before the courts attempt to knock them down. I have no special expertise here, but as I see it, we will be talking about repealing all or most of the Immigration Act 1971, which provides the bulk of the modern system of immigration rules. What will be left? Well, not much. We could be falling back on royal prerogative. What does that mean? The Prime Minister, on behalf of the Crown, by convention, retains certain powers that are not specified in Acts of Parliament. For example, when the government issues a passport, this means the government can look at your application and even though you have done everything right, still refuse to give you a passport. If we abolish the current immigration system, then we could fall back on historic royal prerogatives, such as the power to admit or exclude non-citizens and the sovereign power to control borders. Pub immigration juries could be an application of these powers. However, even these powers are subject to judicial review. Royal prerogative powers can't be exercised irrationally, with an unfair procedure, or with bias. And it's precisely these safeguards that I'm trying to exclude from the decisions of pub immigration juries. Why? Because the moment courts get hold of these jury decisions, they would overturn many of them and insist that juries apply a level of legal professionalism similar to the current system. And if that happens, suddenly the general public is disempowered once again in the area of who is coming into their part of the UK. So we simply cannot let lawyers and judges near this system. And I mean that most sincerely as an ex-lawyer. Once lawyers have a way in, they will force that entry point open wider and wider. That is the nature of lawyers. So what will happen once ministers start ignoring court rulings relating to pub immigration juries? First of all, these rulings will come very fast because courts can grant interim relief to pause the effect of illegal laws. And when a minister carries on implementing an illegal policy, they will quickly be summoned to appear in court to explain themselves. Contempt of court proceedings will begin. The High Court is likely to hand down very specific orders for compliance, with tight deadlines and escalating consequences for ignoring them. Ministers can face personal fines and imprisonment. They need to be brave and put their country first. Senior government lawyers and civil servants will be invoking various procedures to warn the government of the consequences of ignoring court rulings and to protect the integrity of the civil service as it is under the current system. The civil service will soon not be cooperating because they have a duty to follow the law of the land. Other enforcement authorities will be in a similar position or have a dilemma. The matter will have to be dealt with by the Prime Minister and Parliament. The House of Lords will have more freedom to censure the Minister and government and slow things down. The King will need to be advised on his powers to dismiss a rogue government. However, the Prime Minister and House of Commons should, in my view, keep calm and carry on and back the policy. Then we will be in a constitutional crisis. The rule of law will have broken down in a major area of public life. By this point, we will be experiencing tensions in international relations and economic damage, with an overall loss of confidence in the UK as a stable rule of law nation. We could be risking the breakup of the UK if the peoples and politicians of Scotland, Northern Ireland and Wales are not behind us. What would happen? This would be new territory for us as a nation in recent history. Ultimately, it comes down to the will of the people, in Parliament and on the ground. For these reasons, I believe we should lay out all of these steps in a pre-election manifesto to get a clear democratic mandate for them. Then we keep calm and carry on, bravely, but also with the utmost respect for all stakeholders, civil servants, enforcement officers, concerned parts of the community, devolved governments, international partners, business people, etc. They all have a right to be concerned at how their interests could be affected by such seismic changes. They can't see yet if this is a policy of a mad government that will be overturned soon, or the start of a new democratic order. At the same time, stakeholders may have useful ideas to minimise disruption that we should listen to. At the end of the day, if the British people stand with us throughout, then the pub immigration jury system carries on as a matter of democratic practice, with the Constitution catching up later on. How that will work exactly is hard to predict. However, we will have achieved a huge simplification and democratisation of a large area of public life. We will have empowered large numbers of responsible British citizens to take a real, meaningful role in public life in their area. This will have huge consequences across this country and beyond. We will then have the job of explaining ourselves on the international stage. We will have to deal with other nations and the United Nations on the issue of asylum. I will cover these issues in my next video.